Why? Because transferring a retirement account into your trust can trigger unexpected income taxes. When you move an IRA or 401k into a trust, the IRS may treat it as a distribution, which means you could owe taxes immediately, potentially a big tax hit your heirs didn't plan for. Cut 2. Visual of someone looking stressed as they review a large tax bill. Voiceover. Plus, retirement accounts have what's called required minimum distributions, or RMDs. These are the amounts you must withdraw annually starting at age 73. When your accounts are inside a trust, these rules get complicated and your RMDs could increase, costing you more money. Visual. Simplified diagram comparing two paths, one with a trust and one with direct beneficiary. Voiceover. The better way to handle retirement accounts is to keep them in your name during your lifetime and simply name a beneficiary on the account forms. That way, when you pass away, the assets go directly to your beneficiary without going through probate. Cut 2. Smiling family receiving inheritance smoothly. Voiceover. This beneficiary designation overrides what's written in your will or trust, so it's important to keep it updated regularly. If you fail to do this, the account could end up in probate anyway, defeating the purpose of careful estate planning. Visual. Checklist on screen. Do's and don'ts for retirement accounts and trusts. Voiceover. To sum it up, do name beneficiaries on your retirement accounts. Don. T. Put retirement accounts into your living trust. Do. Review your beneficiary designations every few years. Don't ignore tax consequences of trust transfers. Visual. Financial advisor hands client a clear summary sheet. Voiceover. Encouraging, understanding, this one key rule can save you and your family thousands in taxes, legal fees, and headaches down the road. When it comes to your retirement accounts, keeping it simple is almost always the smartest choice. End of scene 1 with on-screen text. Retirement accounts belong outside your living trust. Protect them wisely. Now, let's talk about health savings accounts, or HSAs, a fantastic tool for managing healthcare costs with tax advantages. But when it comes to estate planning, many people make the mistake of trying to put their HSA into a living trust. Cut 2. Close-up of an HSA statement and a living trust document side by side. Voiceover. Here's the catch. HSAs are uniquely tied to you as an individual. They're not transferable assets during your lifetime. This means you cannot simply transfer ownership of your HSA into a living trust. Visual animation showing a no transfer symbol between an HSA account and a trust document. Voiceover. If you attempt to put your HSA into a trust, it could cause administrative headaches or even legal issues. More importantly, it's unnecessary because there's a much simpler and more effective way to handle your HSA in your estate plan. Cut 2. Illustration of filling out an HSA beneficiary designation form. Voiceover. Instead of adding it to your trust, you should name a direct beneficiary on your HSA account. This ensures that after your passing, the funds go directly to the person you choose, avoiding probate entirely. Visual. Someone handing an HSA beneficiary form to a bank representative who stamps it accepted. Voiceover. Your beneficiary can be a spouse, child, or anyone you trust. Keep in mind, if your spouse inherits your HSA, they can treat it as their own. But if a non-spouse inherits it, the account will be treated as a taxable distribution in the year of your death. Cut 2. A simple checklist on screen. Voiceover. Here's what you need to remember. Don't transfer your HSA into your living trust. Always keep your beneficiary designations up to date. Understand how your chosen beneficiary will be treated for tax purposes. Visual. A happy family member receiving funds smoothly after a loved one's passing. Voiceover. Encouraging. Properly managing your HSA beneficiary can save your loved ones from unnecessary legal complications and tax surprises. So, keep your HSA personal and direct, outside of your living trust. End scene 2 with on-screen text. Health savings accounts. Keep them simple. Keep them personal. Let's talk about vehicles. Many people think it's a good idea to put their cars, trucks, or motorcycles into their living trust to avoid probate, but for everyday vehicles, this can often create more problems than it solves. Cut 2. Close-up of a vehicle title and a trust document side by side. Voiceover. Here's the issue. Transferring your vehicle title into a trust can cause administrative headaches, delays, and sometimes unexpected fees at the Department of Motor Vehicles. The process varies by state, and some DMV offices aren't even set up to handle trust transfers smoothly. Visual DMV worker explaining paperwork to a customer with a confused look. Voiceover. Also, if you're still using the vehicle daily, having it titled under a trust can complicate insurance claims or selling the vehicle later on. Cut 2. Animation showing two paths, one with vehicle in a trust causing red flags and another titled directly to the owner with a smooth path. Voiceover. For most people, it's easier and just as effective to keep your vehicle titled in your name. When you pass away, your vehicle typically passes to your heirs through a simple probate process or by using your state's small estate procedures. Visual person handing over car keys to a family member after smooth transfer. Voiceover, of course, there are exceptions. If your vehicle is a rare collectible or used for business purposes, placing it in a trust may make sense. But for your everyday car or truck, the hassle usually outweighs the benefits. On-screen checklist. Don't rush to put everyday vehicles in your trust. Check your state's DMV rules before transferring titles. Consider your insurance and usage needs. Visual person, happily driving their car, with family. Waving goodbye. Voiceover encouraging. Remember, estate planning is about making things easier for your loved ones, not harder. Keeping your everyday vehicles out of your trust often does just that. End scene 3 with on-screen text. Vehicles, know when to trust the trust and when to keep things simple. Voiceover clear and professional tone. Life insurance policies are often misunderstood when it comes to estate planning. Many people think they need to transfer these policies into their living trust to avoid probate or ensure the payout goes to the right person, but that's usually not necessary. Cut to close-up of a life insurance policy document and a beneficiary designation form. Voiceover. Life insurance policies have a built-in mechanism to avoid probate, the beneficiary designation. When you buy a policy, you name who will receive the money when you pass away. This beneficiary designation overrides what's in your will or trust. Visual animation showing money going directly to named beneficiaries without touching the trust. Voiceover. Because of this, the death benefit typically passes directly to your beneficiaries, bypassing probate completely. So, transferring your life insurance policy into a living trust can sometimes add unnecessary complexity and paperwork. Cut 2. A person filling out or updating beneficiary information online. Voiceover. The key is to keep your beneficiary information up to date. Life changes, like marriage, divorce, or the birth of children, should prompt you to review and update your life insurance beneficiaries. Visual. On-screen checklist appearing as the narrator speaks. Voiceover. Here's what to remember. Name beneficiaries directly on your life insurance policy. Regularly update your beneficiary designations. Avoid placing your life insurance policies into a living trust unless advised by your estate planner. Visual. A family receiving a life insurance payout smoothly, smiling, and relieved. Voiceover reassuring tone. In some complex estates, or if you want the trust to control how and when the money is distributed, it might make sense to include the policy in your trust. But for most people, the straightforward beneficiary designation is the smarter choice. End scene 4 with on-screen text. Life insurance. Let beneficiary designations do the work. Keep it simple. Real estate is governed by the laws of the country where it is located. So, even if you put your foreign property into your US-based living trust, that trust may not be recognized by foreign authorities. Visual animation showing a rejected stamp on a document labeled US Trust by a foreign office. Voiceover. This means the transfer might not be effective, and your heirs may still have to go through the local probate or inheritance process, which can be complicated, expensive, and time-consuming. Cut to a legal expert or attorney advising a client, pointing at international documents. Voiceover. The best approach is to consult with an attorney who specializes in international estate planning. You may need to create a separate trust in the country where your property is located or use other legal tools that comply with local laws. Voiceover. Proper planning can help ensure your foreign property passes smoothly to your beneficiaries without unnecessary legal hurdles or delays. On-screen checklist appears. Understand the local laws where your foreign property is located. Don't rely solely on your U.S. living trust for foreign assets. Work with international estate planning professionals. Visual. Family enjoying a vacation at the foreign property. Happy and relaxed, voiceover optimistic tone, with the right guidance. Your foreign property can be protected and inherited according to your wishes, without surprises for your loved ones. End. Scene 5, with on-screen text. Foreign property. Plan globally. Protect loca.